welcome to the Bite Pod. I'm Ann Retho, and I'm joined by Dr. Tim Gilday and Jonathan Tycko. Jonathan is a distinguished attorney specializing in whistleblower representation and Qui Tam litigation under the False Claims Act. His work has exposed hundreds of millions of dollars in fraud, including cases involving customs duties and tariffs. And Mr. Tycko has been recognized as a leader in his field. He served as the co-chair of the Conference Committee of the Taxpayers Against Fraud Education Fund and received the National Law Review's Go-To Thought Leader Award in False Claims Act law. So, Jonathan, thank you for being here. We're excited to have you and excited to talk.
Yeah, thanks for having me on, Ann and Tim. Look forward to chatting with you.
So before we jump in to today's topic, I just want to briefly touch on the Bite platform. This is the Bite Pod. So here at Bite, we do two things. We have a back-end AI-based trade data analytics platform with close to 1 billion records, trade records, and that informs our analysis and drives our compliance and risk management tools. We take the output of that AI model and consolidate it with a more extensive list of compliance data and make that all available to the public through a very easy-to-use web app. The web app, known as Bite, offers a cost-effective toolbox for trade and transaction compliance. This is a low-cost, efficient way for customers to mitigate their trade risk. So with that, we will dive into customs fraud and whistleblowing. So, Jonathan, you have obviously had a significant impact on whistleblowing representation, especially in cases involving customs fraud. Can you take us through what the False Claims Act is and how they work, and just give us a little background on that?
Yeah, sure. I'll kind of give you like the thumbnail sketch of my legal practice, which, as you said, it's primarily representing whistleblowers or other people, or sometimes even companies. We'll kind of get to that, I guess. But we generally call them whistleblowers, who are blowing the whistle on fraud on the government, and that is what is covered by the False Claims Act. It's the primary statute that makes it illegal to commit financial fraud on the government. And one part of that statute, in essence, makes it illegal to evade customs duties. And that's why at least some of False Claims Act litigation involves various types of fraudulent customs transactions where importers are doing various things to try to avoid paying duties or to try to avoid tariffs, or sometimes what are called anti-dumping countervailing duty orders. These are various legal regimes that essentially impose a tax on imports.
And what kind of dollar values are we looking at here when you say these duties, and what are people evading? What is that total to?
Well, as you know, the tariff rate, which is basically the tax rate on imports, varies a lot from product to product, and it varies a lot depending on the country of origin of products. So it can be anywhere, the tariff rate can be anywhere from 0 all the way up to hundreds of percent in the case of certain anti-dumping orders. So in some cases, it's very low. In some cases, it's very high. The way that these False Claims Act cases work is that, if you, let's say, blow the whistle on a company that's importing a particular product and not paying their duties, the amount that you recover in that case can be as high as 3 times the amount of the duties owed. So some of these cases, get into the millions of dollars that are recovered for the government. And then the relator, which is the technical term we use for the person who is actually bringing the lawsuit, the relator receives a percentage of that. And that percentage can be anywhere from 15 to 30% based on a bunch of different factors. So I can give you a couple of just quick statistics. I did a little bit of a survey of False Claims Act cases that had been settled by the government over roughly the last 12 years. and the total amount of those settlements was more than $220 million. And the sort of average amount of that settlement, the average settlement was about $5 million. And then the relators awards, the amount that went to the whistleblowers in those cases was about $21 million. So the government pays out quite a bit of money to the whistleblowers who bring these cases.
Wow. And so, in your experience, what are the most common challenges when people are bringing these cases to the government? What are the common challenges that they're facing under the False Claims Act?
Yeah, I mean, there are certain issues that come up in every False Claims Act case, and then there are some issues that are sort of customs specific. So, in general, the challenge is always proof. So when clients approach us and want us to represent them in one of these cases, we have to spend a fair amount of time, often just developing the case before we ever present it to the government. And that's putting together whatever evidence the client brings to us and whatever evidence we're able to develop with the client over time, and to try to get to the point where we're fairly confident that the fraud we're going to allege in the case is really happening. Because if you go to the government and you don't have good evidence backing up your allegations, you're not going to get very good cooperation from the government lawyers and government investigators who you're asking to spend, you're asking them to spend their time on your case, sort of, right? And so really it's often an evidentiary issue. Can we put together enough evidence to really show that what the client thinks is happening is really happening? I would say in the customs space, um, a lot of the challenges involve the fact that the fraudulent activity may be primarily occurring outside of the United States, in the country that is sending the products to a buyer in the US. And that can be either there is some sort of falsification of what the product is, falsification of the value of the product, or falsification of country of origin. And sometimes those issues are difficult to investigate because the evidence may be in a foreign country. So that's often a challenge that's sort of unique to customs cases.
Yeah. And you mentioned outside of the False Claims Act, but are there other types of customs whistleblowing that you could speak to?
Yes, I mean the False Claims Act is a very powerful tool, but it's not the only tool for sort of triggering a government investigation into alleged customs fraud. The two other primary tools, one is called the Enforce and Protect Act. People generally refer to that as EPA. Um, and there is a sort of an administrative method whereby a complaint can be filed with Customs and Border Protection, CBP. That's sort of the agency that enforces these laws at the border. Now, only certain specified people or entities can bring EPA claims. They have to really be sort of domestic businesses that are being affected by the trade practice that you're complaining about. Um, so that's sort of a limited pool of potential whistleblowers that can use the EPA path, but it is a powerful path if you fall within that category. So if it's a domestic supplier that's sort of complaining about, say, evasion of an anti-dumping order by a competitor, that may be something that would qualify for an EPA action. And then CBP also has what they call e-allegations, which is just that, is open to anybody really that can file something online, file essentially a whistleblower tip online with CBP about potential customs fraud. And then if you follow some additional procedures on top of that, you can actually claim a reward if CBP ever actually recovers money as a result of your whistleblower tip. And that also is an administrative procedure. So those those two, the EPA procedure and the e-allegation procedure, those are administrative procedures run by CBP. They're not court cases like the False Claims Act is.
And what, if any, kind of trends or like policy changes around either whistleblowing or customs fraud in general are you seeing out there? What should importers or be aware of?
Well, I mean, as you and Tim know, the world of duties and tariffs has really changed dramatically, I would say, in the last, decade. Um, there was a period of time when US policy was very pro free trade, and there was a real attempt to reduce tariffs and duties to just allow goods to uh, cross borders without too much of a tax, without too much of an additional cost. That thinking kind of went out the door at some point, and we now are in an era of increasing trade protectionism here in the United States. And the United States actually now has one of the most expensive tariff and duty regimes of any country in the world. So there is a whole host of new tariffs that apply to a whole host of new products from different countries around the world that have come into effect in recent years. And pretty much any time the government is going to impose a sort of a high tax on importation of a particular product, there are going to be attempts to evade that tax, right? We just, any law that imposes a cost on business, somebody will try to evade it. And that is certainly true in the realm of tariffs and duties. And so as the US has just built up its tariff regime, and there are more and more products now that are subject to higher and higher tariffs, um, the end result of that is more evasion. And then what you see is the enforcement wave, right, sort of comes after that. So, it's sort of a three-step process, the way that I think of it. First, the government imposes some tariff. Then it takes a while for the evasion to kind of happen and get detected. And then you start to have the enforcement actions. And then it takes a while for the enforcement actions to sort of become public, because the government's doing a lot of things, investigations, enforcement actions that are not public. And so there can often seem to be like this period where not much is happening, but really what's happening is this whole sort of process is ramping up. And then all of a sudden there's this like explosion of enforcement activity that suddenly becomes public. That's really been going on behind the scenes for quite a while. So I think, just by way of example, we're right at that stage right now with respect to what are called the Section 301 tariffs. These are they were people sometimes call them the Trump tariffs. They were put into place starting in 2018 as part of, essentially trade wars between the United States and China. And it was, initially sold politically as an attempt to try to pressure the Chinese into cracking down on certain types of unfair trade practices, intellectual property theft that goes on in China, and to kind of right some of the trade imbalance that existed at that time between the United States and China. So there was essentially a 25% across the board tariff imposed on, I think, roughly 3/4 of all the products that we import from China, which is huge. China's a major trading partner with the United States. So these very high tariffs went into effect starting in 2018 and 2019. And just now, so now we're in 2024. So 5 or 6 years later, we're now just starting to see the enforcement actions. Just within the last few months, the Department of Justice had the first publicly announced settlements of False Claims Act cases that were brought against importers who were doing various things to try to evade those Section 301 tariffs. And those tariffs are still in place. And again, it's China. They cover a huge amount of goods. So, I think it would be a fairly safe prediction on my part to say we're going to see a lot of enforcement activity around the Section 301 tariffs that, again, has probably already been happening kind of under the surface, but it's going to start to surface over the next few years. And there will probably be more and more enforcement actions made public against importers, more settlements And a lot of these will be these types of whistleblower cases. The settlements that have been announced by the Department of Justice already have all been in these False Claims Act whistleblower cases. We call them Qui Tam cases. That's sort of the Latin phrase for this type of case. But they've all been in that type of case. So whistleblowers really play an important role in enforcing these types of tariffs.
Jonathan, as far as these types of False Claim Act cases that you see, are you able to determine what are more common? Is it transshipment with a false country of origin, undervaluation, misdescription, or what type of in the area of customs enforcement are more common violations?
Yeah, so it's all of that, and so I recently published a survey of I believe it was about 43 public settlements that the Department of Justice had entered into in False Claims Act cases involving customs fraud. And one of the issues I actually looked at in there was, well, what were the types of fraud um, that were involved in those settlements? So the most common, actually, somewhat to my surprise, was just straight up undervaluation of goods. So Tim, as you know, there's basically three ways to lie to CBP about what you're reporting. You could lie about what it is. You can lie about the product. You can lie about the value of what you're bringing in, or you can lie about country of origin. And so I think it was 18 out of the 43 settlements were just pure undervaluation cases. The importers had lied to the government about the value of the products they were importing. And as you know, duties are calculated as a percentage of value. So that's sort of an easy way to reduce your bill to the government, is by lying about value. And that often happens with kind of what we call double invoicing schemes, where the customer here in the United States that is buying the product and bringing it into the country is paying one price, but they get an invoice from the manufacturer of that product in the foreign country that shows a lower price. And then they report that lower price backed up by that fake invoice to CBP in connection with their entry summaries. And so that type of fraud is quite common, and a lot of the cases involve that. The second most common sort of category of fraud, I would say, was evasion of anti-dumping and countervailing duty orders. These are orders that impose very, very high duties, typically on particular products coming from particular countries. So there are sort of two ways to evade one of those orders. Again, you can lie about the product, and as you know, that when goods come into the country, they're sort of classified by HTS code. So a lot of this is just misclassification. CBP will be given one code, but the product that's actually in the container is something else. So some of those cases involve that. And then some of these anti-dumping evasion cases involve transshipment, which is a way to kind of try to disguise the true country of origin. So let's say it's a Chinese-made product that's subject to the anti-dumping order. If that same product came from, say, Malaysia, it wouldn't be subject to the anti-dumping order. And so what the manufacturers do is they move the product from China to Malaysia, they repackage it into something that says made in Malaysia, even though it was actually made in China. And then the ship that comes to the United States is coming from Malaysia. And then on the entry summaries, the importer will say, "Oh, this product is made in Malaysia, not China." So that form of transshipment is often involved in these settlements. And then after that, there are just other misclassification cases, and then a small number of what are called marking duties cases. And these are cases that are brought under a separate provision of US law that requires that imported products be accurately marked with their country of origin on the product themselves, typically. And so if that isn't done, or if the marking on the product is false, that automatically can subject those products to an additional 10% duty. And if this isn't detected by the government at the border, and subsequently brought to the government's attention by a whistleblower, that can be the basis for a False Claims Act case. So those are kind of the rough sort of types of evasion. And so, you can see it's kind of across the board. It's like all the different ways you can cheat on customs, and they all kind of surface through these False Claims Act cases.
I'm surprised it would be undervaluation and that double invoicing scheme, because there's certainly a record there
There
between
is,
two
yeah.
companies. So there's higher risk associated, but that would be true of transshipment, the other ones as well.
Yeah, I think, you know, customs fraud, I think, is a little bit is very similar to tax fraud in a lot of ways. And one of the ways that it's similar is that the people that are engaged in the fraud are very calculated about it. They understand the risk, but the other part of that calculation is, what is the chance I'm going to be caught? And I mean, Tim, you can probably speak to this better than I can, because you have better insight than I do into sort of what CBP's, sort of abilities to catch customs fraud on its own are. But my sense, from what I've been told at least, and what I've read, most of the products that come into the United States are never subject to inspection.
Right.
And the vast majority of the customs transactions are just done, through electronic records. There's very little auditing of those transactions. It's done on trust.
Yes.
Just because the volume is so high. I mean, there would just be no way to police everything coming across the border. You just got to get the containers off the ship, get the next ship in there. You can't put too much grit into those wheels of commerce. And so I think part of the calculation that the cheaters do is, yeah, I might get caught, and if I get caught, it'll be bad, but the chances of me being caught are low.
Right.
And I think that's really why some of these schemes, once you see them, they're totally obvious. They're totally obvious. But I think there's a lot of totally obvious fraud that just never gets caught.
One of the risks for the violators, though, and we did these types of investigations, we relied a lot on source information from the industry. So competitors could see that these were coming in at prices that weren't realistic. They also had, we'd say, disgruntled employees, right? After the fact would come in. Maybe they got let go, or they had some conflict with the company. So even though they get it through and they pay the lower duty or no duty, whatever it is, the records don't go away. So obviously it's better to do it correctly than to always be wondering when the knock on the door will arrive.
Oh, yeah, absolutely. Like from a compliance perspective, if I was advising a company that was doing a lot of importing, right? These kinds of cases are costly. If one gets brought against you, you don't want to be on the receiving end of one of these False Claims Act cases. You have the government coming after you. You have a whistleblower in the background urging the government on. You're subject to treble damages. So if you owe the government $1 million, the government come after you for $3 million plus penalties on top of that. Then you got to pay the legal fees. So these cases can become very costly to a business very quickly if you get caught, right? And so, if I was on the business side advising the business, I would say, you got to be careful. I mean, certainly the people who are just going to do it intentionally, they're just criminals. They're going to do it intentionally anyhow, right? But a lot of what happens, I think, sometimes is you have a importer, a company here in the United States that wants to import and sell some product. And the question is, okay, is what we're being told about this product really true? That's sort of the question. Is what we're being told about what the product is what we're being told about what the country of origin of that product is? Are these things true? And the CBP, I think, expects importers to do some level of due diligence. They're not guarantors. They're not guarantors of the truth, but they have a duty of reasonable care. They do have to at least avoid obvious mistakes and do some due diligence, particularly if you're a major importer that's importing a lot of stuff. you do have some obligation to do some due diligence. I know that's what, your business kind of specializes in, and is certainly, just using data, I think is increasingly important. We use data analysis in our cases sometimes to try to help prove the fraud. But at the front end, if a business is trying to comply, I think you have to at least look at, what is this company in Malaysia? Who are their other customers? Where are they getting their products from? What can they give us that would actually prove that the product was made in Malaysia and not in China, by way of example? You got to do a little bit of due diligence, I think, to satisfy CBP.
Right. And the key points are, one, we agree most companies they want to do the right thing, and they may be unwitting if they are associated with a violation. They have the obligation of reasonable care, as you stated, to perform due diligence. And our Byte platform tries to bring all of that due diligence, all of the data sets, the commodities, the entities that the trade community needs to check into one platform, and allows them to run it very, very quickly at a low cost. So we are right on the same page. Most companies want to do the right thing. They have to be careful, though, and apply that reasonable care standard to their transactions, and not just accept information without checking at some level.
Yeah, and if you don't check, the government's going to check, or I'm going to check. Right. So, or one of my clients is going to check. So that data is out there. There's actually a surprising amount of kind of just publicly available trade data like out there in the world. So you can often see products moving around. It's very interesting, and you kind of dive into that world of trade data.
Yes.
And you could track individual ships these days. I mean, you can
Right.
buy access to actually watch a ship go across the
Right.
ocean and see the path it took.
And customs
all
is
sorts of stuff.
using that data more and more as well.
Yeah, right. So I think if you're the importer, it's better to look yourself before somebody else looks at what you're doing.
Thank you.
Yeah, I would totally agree with that. And if you're a whistleblower, if you're one of my clients or somebody that's thinking about blowing the whistle on some sort of customs fraud, that type of data analysis is crucial to those kinds of cases as well. Because if you go to the government as a whistleblower and you say, okay, company X is transshipping, a product from China through Malaysia. I hate to keep using that example. I'm not trying to be mean to Malaysia. It's just that we know that does happen,
You can
right?
say Singapore.
Okay, Singapore, Malaysia, Vietnam, India. These are the countries that tend to be the transshipment points. But again, like if you're going to go to the government as a whistleblower, or as a competitor that's bringing one of these cases, because competitors can bring False Claims Act cases, and we sometimes are actually representing domestic industries that are bringing these cases. You're going to want to look at all of that publicly available trade data before you go to customs. Because again, that's the first thing that CBP is going to do when they get one of these cases. They're just going to dive into their own database, try to figure out what's going on from the data. And so you better know what that data is going to show, and see if it helps you build your case. So like the Byte products and that other sort of types of data that are out there are super helpful in building these kinds of cases as well.
I like that, blowing the whistle on customs fraud. We might start using that tagline, Jonathan.
Well, I haven't trademarked it, so it's all yours.
Thank you. All right. Tim, did you have any final thoughts?
No, I just I want to thank Jonathan. We see the same trends on the horizon. There are going to be more barriers. There'll be more enforcement. The period of facilitating trade and lowering barriers, streamlining those processes are not the priority they were, say, in the 90s. So it would be in the trade community's interest to be proactive in doing their due diligence and applying reasonable care, because this is an enforcement posture I don't think is going to change for quite a while.
Yeah, I agree with that. I don't think the trend is going to reverse for at least the next couple of presidential cycles.
Yes.
So, yeah.
And Jonathan, any final thoughts from you? I'll give you the closing word on that.
I can talk endlessly about this because I think it's such a fascinating intersection of like international trade, which is super interesting, and the False Claims Act, which is also interesting on its own. So I feel sort of lucky to get to work on these cases, um, and certainly, if anybody wants to reach out to me to talk about some of the legal issues, I'm always happy to do that. Um, we have a whole website that's devoted to the False Claims Act. Can I plug the website? Is
Sure,
that okay?
definitely. Go
Yeah,
ahead.
so our firm's website that is all about False Claims Act and whistleblowing is fraudfighters.net, fraudfighters.net. So there's lots of information on there, and you can also find me there if anybody wants to reach out. But thank you, Anne and Tim, for having me on. It's been an honor to talk with you.
Thank you.
So that wraps up another episode of the Bite Pod. I hope you enjoyed exploring customs fraud and whistleblowing with us today. And don't forget to check us out on social media on Instagram and LinkedIn. And if you're interested in a demo of Bite, feel free to reach out to us either on our website at bitedata.io, or you can email us at bite@newborders.com. We also offer free trials of the app, and you can sign up for that at app.bitedata.io. And don't forget, you can visit Jonathan at fraudfighters.net. So thank you all, and we'll see you next month.